Hello, and welcome to Business of Design. We're so glad you're here. I'm Kimberley Seldon, and hey, I'm so glad I'm here. I've been on the road again, and it's been a long time. COVID interrupted a lot of that. But I had the pleasure and the honor to be part of the BOD Boss Group in Dallas last week, and what an amazing experience it was. I actually have goosebumps thinking about it. We've dreamed of setting this group up for so long. I created boss groups to be what I desperately wanted as an ambitious designer: a planned path for growth, strategy, and the motivation and accountability I needed from other professionals working the way I was working. And I'm happy to say that it has not only met our expectations, but actually wildly exceeded them. We are forming another boss group. May 4th, we're having an information Zoom meeting, everything you want to know about boss. And unlike the first time we held this meeting, it was Cheryl, it was Janine, it was myself. Unlike the first time where we had hopes and dreams for the group, this time we have concrete testimonials from actual boss members who not only say it's working as expected, but it's working beyond their wildest dreams. So I couldn't be happier, and we would love for you to consider applying to be a boss member. So come out on May 4th and find out what that is all about. May 4th, 1 p.m. EST. It will be recorded. You do have to register for the event, although it's free. So immediately following the boss adventures in Dallas, I flew to Santa Monica, and we hosted the BOD Elite Retreat Santa Monica. And again, oh my gosh, it was epic. It was so great. And the group has pushed me to raise my rates in a twist on the usual, which is kind of amazing. Not only that, there were a dozen other things I need to implement based on the conversations we had. And the 2 private homes we toured, I can't even tell you how exceptionally gorgeous they were. And to spend time with the architects was really amazing. And I think we were all inspired and just ready to come back and do better work, aim higher. You know that feeling. So hopefully you'll join us next year, Elite Retreat Malibu. We're going to focus our attention on further down the coast, and we've got incredible lessons already in the works being created for next year, April. So think about that. And for those of you who are BOD members, and I hope that's everyone listening, if you haven't done it yet, really you should. But if you are a BOD member, on the 11th of May, we will be dissecting top line. What is top line? How do I use it? How does it work? How does it keep my team accountable? That is happening on May 11th. Now, you're probably wondering about this show. What about this show? This is an amazing episode. I was so happy to meet Thomas Nation. He was referred to us by a BOD member, and we were able to have a conversation based on his experience in construction law. He's a solicitor for Harrison Clark and Rickerbys, hcr.com, and you'll hear Thomas mention the website as well. So if you are in England and you would like legal counsel, this seems like a great place to start. Thomas clears up some of the confusion around how we might procure safely on behalf of our clients. But as always, we encourage you to seek local advice and make sure you're always compliant federally and locally. And make sure your insurance covers your method of operation as well. Thomas has great advice about the difference. Again, this is for England, the difference between being an agent and a principal. I actually function as both from time to time. And most importantly, what needs to happen in your contract to make sure that you are in compliance. We're really glad you're here. Let's get right into the show.
Welcome to the Business of Design podcast with Kimberley Seldon. Business of Design is the world's best business training for interior design professionals like you. We have the systems, strategies, and protocols you need to consistently satisfy clients, increase profitability, and run your projects like a boss. Unlike traditional coaching, BOD is a fast track to immediate results. Don't try to do this alone. Join today and you'll have access to hundreds of targeted training modules, plus member perks like BOD Live events, member-only podcasts, preferred pricing, and the support of an engaged community of peers. We all know design matters. At Business of Design, we think designers matter too.
Well, thank you, first of all, Thomas. I was looking forward to this, and I expected you to be significantly older.
Oh, I think you're flattering me there. Flattering me.
That's hilarious. So we got your name and information from a Business of Design member, Lisa Burtis, and she's originally from Australia, from Sydney, but she moved to the Cotswolds, and somehow Lisa ended up speaking to you and suggested that we get in touch, and I was thrilled with the introduction.
Yes, well, thank you to Lisa for putting our name down. Thank you.
Yeah, excellent. We have a complicated problem that only somebody who has experience can probably give us any insight into. And the problem for interior design professionals increasingly is a set of restrictions around what we can and cannot do on behalf of our clients, specifically what we can purchase on behalf of our clients. So the way it works in the two cities I live in, which are Toronto and Santa Monica, is if I am a consumer, if I am Mrs. Smith who wants to decorate my home, I can hire anyone I want straight out of a Yelp review or off the street, or go down to the Home Depot and pick them up and put them in my car and bring them home and have them renovate my house. That's okay. That's allowed. But as an interior design professional, I'm not supposed to be able to hire a plumber, for example, or an electrician or a contractor that I've worked with for 20 years on behalf of the client. Somebody that I've vetted, somebody I can vouch for, someone who's honorable and does good work. I'm not supposed to be able to do that. And it doesn't seem to make a lot of sense. And all of us are kind of looking for a workaround.
Right. Okay. Well, that's interesting, Kimberley. I mean, I should say, first of all, so my expertise and knowledge is in English law. So I can certainly give some pointers for your members about how it works here. I know you've got members all over the world, particularly in Canada and the US. And I have to be honest, I have no idea how the position works there. But what people often ask us about, I should say, I'm a solicitor, and our firm's Harrison Clark Rickerbys. We top 100 UK law firm, but one area of practice that I'm in is construction industry law, which interior designers do fall within the ambit of that. And what we're often asked about is what's the difference between supplying goods or, say, services, which you mentioned there, as a principal or as an agent. And I think that sort of ties into what you're talking about there.
Can you define for us what it means, principal versus agent, what those two terms mean? Absolutely.
And I think a lot of people get hung up on this, but actually the distinction is quite straightforward. If I'm supplying something as a principal, I'm just a retailer, really. And that could be that I've got a literal shop, physical shop, or an internet shop. But probably, if I'm an interior designer, I'm supplying stuff. So I'm thinking FF&E, furniture, and so on, mostly here. I'm supplying it as part of a package, aren't I? So I've got a consultancy package with my client, and I'm supplying it as part of that package. That's pretty straightforward, really. So I buy it in, or make it even, and sell it on, hopefully at a profit. So that's what that is.
Can I clarify that? So I'm a principal. I don't have a bricks and mortar store. I do make purchases on behalf of clients. Is that a principal?
Right. So if you're thinking about making a purchase on behalf of a client, I think what you're talking about there is being their agent. So the difference there is that someone else, another retailer, say, could be a brick and mortar store, they're supplying the item, but I'm just helping to coordinate that as the agent. So I think the example I often give, if I'm trying to explain this to people, is imagine you were going to go and get some very specific piece of art for your client, so Rembrandt or something like that, you probably wouldn't, would you, Kimberley, go down and buy it yourself at an auction and then try and resell it on with a markup, would you? What you would do is you would go down to an art gallery, speak to a dealer, or go to an auction on your client's behalf, and procure it and help to be the middle person, I suppose. That's agency, I suppose. Put very simply, you're an intermediary facilitating it. Does that sort of make sense? Or
well, okay, let's use an example that's not a Rembrandt, because that maybe throws what people are expecting. But let's say I want to purchase a beautiful piece of furniture, a dining room table, on behalf of my clients. My clients are super busy people. They trust me. I show them a picture of the dining room table. I tell them this is what it costs. And then they give me the money and I go and purchase that dining room table. Because I have experience purchasing, I'm going to be able to ask all the right questions when I'm placing that order. For example, is delivery included? Is this a walnut finish? Is this a hand wax finish versus the high gloss finish I see? Right? There's going to be a number of things that I'm going to want to secure when I'm placing this order on behalf of the clients. But in fact, I do ask my clients to give me the money and I go and purchase the table.
I see. So I think what you're talking about there is purchasing as an agent. But I would want to say there that the important thing is clarity. I think clarity as to the relationship is key. The relationship between you, your client, and whoever it is you're getting this item off of. Because ultimately we could go and we can't really do a tick box exercise necessarily and say, oh, well, you did this and you did this, but you didn't do this, therefore you're an agent. It's the objective position that we need to look at, really. So my advice there is if that's how you want things to be done, if you're going to be an agent, you really need to make that clear to your client at the start. And I can talk a bit more about how that's often done in contracts, but if that would help. But I hope that's sort of making some sense for you.
Yeah, absolutely. And that is clear in my contract that I will do that on behalf of clients. My contract also says that the fact that the clients have given me money to make the purchase is their approval that I'm going to make the purchase.
Sure. I suppose it's a difficult one, really, because you're sort of describing the situation where you are. But I think, when if I'm advising interior designers in England, the money is quite important, and just making clear what purpose it's being given for. When you're acting as an agent, you're doing more than just getting the goods for them. You are taking on quite a lot of responsibility as a professional for your client. You are acting on their behalf. So any money that you're receiving, you need to be very clear that whose money, that it is their money that you're spending on their behalf. Whereas if you were to go and sell goods at a profit, that's a slightly different thing. I hope that's sort of making some sense.
Right. It sounds like if I'm on holidays in Paris and I find a vase that I love and I purchase that vase and then later I sell that to the client, I'm acting in that case as the principal.
I think so. That's right. That's right. So you're buying something and selling it on.
Okay. And I suppose, and I know laws are going to vary by every country that is listening. So you absolutely must seek legal counsel where you live. But part of the solution seems to me to be a contract that is clearly written so clients understand exactly how their money is being used, what it's being used for, and what our obligation is when we take their money.
I quite agree. So as you say, a bit of a disclaimer. I'm just sort of talking in general terms. Do get your own advice, whether you're in England, whether you're in America, whether you're in Ireland or whatever it is, because all these things will be a little bit different. But clarity as to the relationship is absolutely key. And, whilst you can have a contract that is verbal, if there was ever any argument as to what was and wasn't agreed, it's all a bit difficult, isn't it? So having a contract that's very clear and in writing, which lays out what your responsibilities are towards your clients, what exactly you're going to go and do, is absolutely essential. And there are a number of ways that's commonly done in England, which I can talk about. I just want to talk about another thing, if it's okay, Kimberley, which I think a lot of people perhaps don't quite appreciate when they're acting as someone's agent and going and getting, for example, a vase or whatever it is really, is that you do need to be very clear about, let's come to your money point, that you can't make any kind of profit on doing that which isn't disclosed and agreed with your client. And that includes actually even trade discounts, which if you don't disclose them, but if you get the benefit of them, then that is, certainly in England anyway, probably going to be unlawful. And that's another reason why having a contract that lays out the position very clearly is important, and lays out any commissions or any time that you're charging for and profit that you're making.
Interesting. We don't say exactly what our commission is, but what we say is we will share 50-50 any trade discounts. So if a chair costs $100 retail and we purchase it for $800 wholesale, we sell it to the client for $900, and the client knows that the chair cost $1,000 retail. They know that it was $800 wholesale, and they know that we've sold it to them for that price in the middle.
Right. So if you're acting as the principal and you're going and buying this item and then reselling it, you can charge what you like, really, and you don't have to disclose what you got it for. It's when you're acting as an agent where this clarity is really important. You're acting for them. You're on their side, if that makes sense. Mm-hmm. So everything needs to be transparent with them, if that makes any sense.
Yeah, and I guess it sounds like I do both. I'm a principal and I'm an agent, and therefore my contract needs to make sure it covers me in both of those functions. Yes,
I think I agree. I mean, again, accepting you're in Toronto, but that I've advised quite a number of interior designers in England to do a bit of both, depending on the circumstances, and I've helped them with their contracts and making sure that it covers both scenarios. But I think it's the clarity, and I don't just mean in written contracts, but also sitting down and having a chat with the client, really, and mm-hmm. so that they understand where they are, so that they don't come back and feel that things weren't clear. I mean, there's quite a lot that could also be said about all this in terms of liability for. We'll just talk about goods for now. For goods, if something goes wrong, because all of that varies as well in terms of in terms of whether you're acting as an agent or as a principal.
Wow. I'm also thinking that is there a distinction? I know we've talked a fair bit about goods, but what if I'm hiring the painter? And again, we ask our trades to give us preferred pricing. So the price that they're going to give me as someone who hires them repeatedly is different than the price they're going to give Mrs. Smith, who they met on the street. And we have both of those prices in writing, and we share that difference with our clients. And again, that's in my contract. But does the law, I guess the law might change vis-a-vis trades versus goods?
I think it's something we could go on and on about. I mean, certainly there are all sorts of regulations that apply to supplying goods as opposed to supplying services. But you certainly can act as an agent with respect to supplying, the coordinating some other tradesperson to do a specialised job, and that goes on all the time. Or you can do it yourself. That essentially you're that you're also making the supply for of whatever it is. So I think it's the same sort of principles apply, in that you've got to have absolute clarity and understanding. And I think also, Kimberley, it's not just about clarity with the client. I think when you're placing an order and making that contact with whoever it is who's supplying the goods, say, it's making clear that they understand the relationship and who they are working for. Because if you're the agent, they're the principal, but they need to know that they're selling it to your customer, and that you're just there to coordinate things and to help organise things and so on. There's quite a lot of things that could be talked about here in terms of how liability can work and the sorts of contracts that are available, and I could talk a little bit about those if you like, but over to you. Really, it's sort of what.
Oh my gosh, yeah, no, we could spend days and days talking to you, but I guess the bottom line is you have to consult with someone who has expertise in the field, who can advise you on what needs to be in your contract and what are best practices for you, so you avoid getting yourself in trouble. And I guess getting yourself in trouble would be the threat of a lawsuit or a lawsuit.
Yeah, so I suppose some of the pitfalls that are there, some of the risks that are there, is if goods are supplied and something's wrong with them. Hopefully we're just talking about they're faulty or something rather than they're dangerous. Who's actually liable for that? Now, in England, there's all sorts of legislation that comes into play about this, and I won't list off a whole load of acts of parliament because I think it would send you and your listeners to sleep. But I'll just focus on one bit, which is the Consumer Rights Act, which came in 2015. And one of the things that says is that goods supplied have to be of satisfactory quality, and if they're not, consumers have got various rights to return them and so on. And the thing that's really important here is that these rights only apply to people who are not in business. So I think that for most people in your trade, I think a lot of your clients are domestic customers, but it'd be different if you're dealing with a business. And so the clarity as to who's actually supplying the goods is really, really important. Whether you're the principal or the agent is really, really important. If you're selling as the principal and there's a problem with the goods, potentially this is on you, if that makes sense. If you're acting as an agent, as long as you're within the scope of what's been agreed as an agent, as long as you're acting within your authority as agent, the liability is on the supplier. Now, that's not to say you won't try and help, as I'm sure you would, and clients are going to want a single point of call, so they're probably going to call you up anyway. But in terms of the legal liability, the bottom line for goods, if you're supplying as an agent, that is on the retailer. Now,
and there it is. As I was listening to the edited version, I thought that this bears just a little explanation and maybe some hammering home the fine point. The bottom line is these two categories, agent being the person who procures on behalf of the client, acting as the client's representative, but not necessarily making a markup on goods, and principal, purchasing still on behalf of a client, but making a markup on goods. In both scenarios, and again, this is English law only, and these are generalizations, so you really do want to make sure you seek your own legal advice. But in both of those scenarios, the key is to be clear in writing with your clients about how you're working and where the money is at all times. There's no getting around it. Transparency and clarity are the key to survival. And Thomas makes it really clear here that even if you go the agency route in this example and you procure on behalf of clients, but you don't have any profit built into that procurement, that does limit your liability for sure, but it is not a bulletproof vest. When litigation happens, everybody gets sued. That's how it works. And you could find yourself in a situation where you're having to take responsibility and liability, financially at least, for a situation that's gone wrong. Which is why I would rather act as a principal in this scenario where I do, in fact, have a percentage of profit built into the product I procure on behalf of clients, And in the event something goes wrong, I will take the percentage that I've earned and I will make the problem go away. And when I say go away, I'll make the problem right. I'll correct the problem for the client, because a lawsuit happens because the client is dissatisfied about something. And I think all of us agree our job is to make sure that when that happens, we come up with a resolution. And let's be honest, sometimes the fastest way to resolve something is to throw money at it. Everybody's frustrated, everybody's exhausted. Some number would fix the problem quickly. And I want to always be in a position where I have available to me that number, if that makes sense. Hilariously, I'm out sourcing tile right now, so I'm recording this on my phone, and I just felt the need to add this to the show before it aired. Let's get back into the conversation with Thomas. Thanks for letting me butt in.
And, in terms of avoiding lawsuits, as you say, I really don't recommend anyone go around and have, say, profits that aren't disclosed, commissions that aren't disclosed, or take backhanders. I mean, we all know it goes on with unscrupulous people. But in England, certainly, if you're taking a benefit and not disclosing it, in theory, you could come within the Bribery Act, which is really quite serious. So it is something that I do suggest people at least have a think about. I'm not trying to scare everyone, but it is something that I suggest people do have a think about. Does that mean they go and speak to lawyers like ourselves and get some specific advice? Possibly. We certainly something we do at times is draft contracts that deal with things specifically as an interior designer wants it.
I don't know. I think hiring a quality solicitor is a really good investment in my future. And most of us have a terrible fear of being sued, or so that's why my policy has always been be as transparent as possible so everybody knows who's making money and how they're making money and how that works. And then perhaps, I mean, we hear this from designers all the time. They're very afraid of being sued, very afraid of that. But what reason would there be to sue you if everybody knows exactly how you're making, who's making money, and when, as you say, something goes wrong, you're willing to step up and fix it?
Yeah, I mean, there's the risk of a dispute and the risk of being sued is always there in business, isn't it? It's just a reality. And it's a risk that I suppose everybody, be it solicitors or be it interior designers or decorators, have to always think about. But having a contract and an agreement that has been tested is clear, and having a relationship which everyone understands where they fit in is always is really going to help avoid it. Hopefully, I mean, if everyone understands where they are, they're less likely to. Because I think a lot of disputes, don't they? And I'm sure you've come across this, come from people not understanding where they are or feeling that things weren't clear. So I think you make a good point there.
Your focus is construction law, you said. So what keeps you up at night? What are the situations that come across your desk that are keeping us all busy?
Oh, right. So I mean, doing construction law, we might act for all sorts of things. I mean, interior designers are one batch of our clients, certainly, but we also deal with property developers or bigger building contractors, or other professionals like architects, people like that. So anyone in that ambit, we might work with, or even people who are building their own house, say, want some help on getting the contracts in place. In terms of what keeps me up at night, I think I'd focus on, for interior designers, I think, rather than get into a big lecture about all the things going on in the construction industry. I think it's the things that I would flag are you properly insured for any problems? Do you have the right sort of insurance, and do you understand what is covered and what isn't? There's different types of insurance that professionals get that cover different scenarios. Do you have what you need? Have you got a contract that works, that's legally enforceable? Does it work? Is it clear? Does it lay out the reality of what's actually going on and what's being agreed? And yes, I think just coming back to what I said earlier. Have all the, especially if you're acting as an agent, have all the benefit you're taking, the profit, be it as a markup or as a time-based charge, is all that transparent and clear. Those are the main things, I think, that in this realm of what we're talking about, those are the things that
do you end up working, do you deal with a lot of negligence? Do you find yourself looking at a situation where somebody's just behaved badly?
Certainly it's something we do. So we do both sides of legal practice in this. So one being, it's often called contentious, which is disputes, and that covers things like breach of contract, negligence, as you say, people who have a duty, which means someone has a duty of some kind that the law recognises, and they breach that, which that can sort of go beyond what's in a written contract. We also deal with the non-contentious side, which is sort of setting up contracts or giving a general commercial or legal advice on commercial relationships, I suppose.
Oh, my goodness. Well, thank you so much. I think we had scheduled this a couple of times. I'm pretty sure you had COVID in the meantime.
I did.
Did it go pretty quickly for you?
It wasn't the greatest week or two of my life, but, got through it okay, thankfully. So, be thankful for that.
At this point, I haven't had it. So I'm starting to feel like excluded. Like, what's wrong with me? Why can't I get it?
I can assure you that you're not missing out that much.
I keep thinking if it continues to be this crazy busy, I'm just going to say that I have it and take a week off.
No comment from me on that.
You're my lawyer. You have to keep that secret. Thomas, thank you so much for your time today. We really appreciate it.
Very welcome, Kimberley. Really enjoyed coming and speaking to you. Apologies, got a bit delayed by the old virus and all that, but I hope that was at least slightly useful and interesting. Just on this area of agency and principle, that I think is an area of quite a lot of confusion, I think. But as I say, we're established top 100 law firm. We have a website. It's hcrlaw.com. If anyone wanted some more specific advice, they're welcome to get in touch with us using that.
Thank you. Yes, if you're one of our UK listeners, or I suppose I should just say if you're one of our listeners from England, yeah, absolutely. Thank you so much. Stay well.
Thanks, Kimberley. You too. Thanks. All the best now.
Thank you for being part of the Business of Design community and supporting BOD's mission to improve the industry one design business at a time. It's time for you to take the next step and join Business of Design. Like thousands of design professionals in 50 countries around the world, you'll find the systems, strategies, and protocols you need to dramatically improve your business and transform your life. What are you waiting for? Start today.